Name is Aziz Chowdhury, and I am happy to be here on behalf of Keller and Heckman and our e-vapor tobacco and nicotine team to present here at the Champs Trade Show about the federal and state regulation of nicotine products. I'm going to share some slides here and get into the details of the latest of what's going on with FDA, primarily FDA, and also with the state enforcement as well. Right, I'm going to share my screen here. Okay, hoping you guys can see that. But again, pleasure to be here, and my contact information is available here. Feel free to reach out to me if you have any questions or concerns about FDA regulation or enforcement. Just a brief background for those of you who may not be familiar with our law firm, Keller and Heckman. We are based in Washington, D.C. We are an internationally renowned firm focusing on regulatory and public policy law. We advise companies in a number of different industries, including food, drugs, chemicals, cosmetics, medical devices, cannabis, CBD, hemp, and of course, tobacco, nicotine, and e-vapor. We have offices around the world, San Francisco, Boulder, Colorado, Brussels, and Shanghai, in addition to our DC base. Total firm-wide, we have about 85 attorneys and close to 20 scientific staff, and we've been around since 1962. All right, so now I'm going to jump into the regulatory background of how we got here in terms of FDA regulation of tobacco products. So this all actually started back in 2009 when Congress was given the authority or I should say, when Congress gave FDA the authority to regulate tobacco products for the first time. And they did that by enacting the Tobacco Control Act in 2009, which defined tobacco products broadly to include any products made or derived from tobacco. That, of course, included traditional cigarettes, smokeless tobacco, and RYO, but it also extended that definition to other categories of products, including e-cigarettes and oral nicotine pouches. However, the regulation of those new products or deemed products did not go into effect until 2016, August 2016, when FDA promulgated the deeming rule to extend that authority to the next generation tobacco products. And then in 2022, Congress changed the law again to redefine tobacco to include not just tobacco-derived substances or nicotine derived from tobacco, but to also include nicotine from any source. And the reason for that was intended to capture synthetic nicotine, which had come onto the market. So there are three different pre-market authorization pathways. Pre-market authorization is required for any new tobacco products, right? So anything that's been introduced or modified since the grandfather date back in 2007 is subject to pre-market authorization. And there are, in fact, three pathways to introduce a new product to the market, including substantial equivalence and something called the substantial equivalence exemption. However, I'm going to focus today on the PMTA, the pre-market tobacco application, because that is the type of application that applies to the majority of new products, including vape products, nicotine pouches, heat not burn, things of that nature. Now, for a PMTA, the legal standard for a PMTA is a very high standard. It is the appropriate for the protection of the public health standard, APPH, as it's known. This is, in my opinion, a very high standard. Again, it's very difficult scientifically to demonstrate, even higher and more difficult, I think, than the new drug standard, which is safety and effectiveness. The reason for that is because it requires FDA to not just evaluate the impact and safety of the product on the individual consumer, but also to evaluate the overall impact on the population as a whole. FDA must evaluate the risk and benefits to the entire population, including both users and non-users, taking into account things like the potential that that product could have on the overall likelihood of consumers quitting tobacco products, as well as the overall likelihood of consumers that could initiate tobacco products, in particular youth. So this is a very broad multi-factor standard that requires a significant amount of scientific data to demonstrate. In addition, for flavored e-cigarettes or vapor products, FDA's position for several years now has been to meet that standard, a very specific type of data or study is required that requires demonstrating that the flavored product, which is a non-tobacco flavor like menthol or strawberry or any flavor, you have to demonstrate specifically that that flavor has an added benefit over and above the tobacco flavor in terms of helping adults, smokers, switch from cigarettes or significantly reduce their cigarette intake. What does that mean? Well, it means that FDA has always been concerned about youth use of vapor products, in particular flavored vapor products, including menthol. And the presumption is that kids will gravitate or and use flavored vaping products simply because these products are flavored. And so in order to overcome that presumption, that known risk, companies must do a specific type of study, a switching study, to demonstrate why a flavored product is more effective than a tobacco flavored product, which does not have a youth risk concern for adult smokers. So FDA is basically saying, we're not concerned that kids are going to use tobacco flavored vapor products. And so if you want to market a flavored product, since we know that kids are likely to use those types of products, you have to show us why the flavored product is significantly more effective than a tobacco flavored product in terms of adult switching in order to justify coming to market and posing that risk to kids. So it's a high standard, to say the least. And it only applies to e-cigarettes, vapor products, because what we know is that, as we'll talk about in a moment, when it comes to flavored pouches, for example, or flavored heat-not-burn products, FDA has not required that specific type of comparative efficacy study, right? So to get a flavored Zyn authorized, Philip Morris did not have to compare the benefit of that flavored pouch to a tobacco flavored pouch in terms of adult switching or cigarette reduction. They had to show other data. They had to show that this was still appropriate for the protection of the public health, but they didn't have to do that specific type of comparison to to a tobacco flavored pouch. Okay, so how is the PMTA process supposed to work? Well, the way it's supposed to work is at 3 phases of PMTA review. There's acceptance, filing, and then scientific review. Okay. In the first phase, once you submit an application, it is immediately reviewed for completeness in terms of administrative information, all the proper forms, the basic information needed to ingest and process the application. Okay, it's a very low bar in order for companies to get an acceptance letter from FDA. I cite on this slide here a couple of the of rules that identify the key information and documentation needed to get through the acceptance phase. Where we see many companies fail at this phase, and FDA has been much more stringent in the last few years, are things such as missing certified translations for documentation or information in the application that might be in another language. Or, for example, missing a right to reference a master file, a tobacco product master file that is not properly referenced in a PMTA will result in that application being not accepted. If an application is accepted for review, then it will go into the second phase, which is the filing phase. The filing phase I describe as sort of a mini scientific review. It's not a full-blown scientific review, which is the third phase, but FDA looks to see if the application contains the basic scientific information needed to be considered complete, including studies on the HPHC, chemistry, toxicology, and PK data. That's called pharmacokinetic data. labels, complete environmental assessments and marketing plans, full descriptions of the manufacturing, quality controls, ingredients, etc. So again, having that type of information um, is critical to get an application filed with FDA. Most recently, in the last several months, we have seen an increased number of pouch applications getting refused to file letters for not having adequate HPHC data, stability data, or PK data. Keep that in mind. If an application does get through the filing stage, then it is supposed to go into scientific review. That is where FDA reviews all the actual data in the application, the different disciplinary review teams, such as engineering, toxicology, behavioral, clinical, pharmacology, microbiology, all of that stuff gets reviewed by the FDA scientists. And once FDA begins that scientific review process, it is supposed to take 180 days. The statute says FDA should not take more than 6 months to complete that scientific review. In practice, as we'll see, that has basically never happened, at least for a vapor product. And during the scientific review phase, FDA is supposed to, they're not obligated to, but they're supposed to, by guidance, issue at least one deficiency letter to the company, to the manufacturer, to notify them of their questions about the application. And typically the company has about 90 days to respond to those questions. Okay, but how has it actually worked in practice? Well, in reality, very few applications have actually gotten to the scientific review phase. The reason is because during the height of PMTA submission process after the first PMTA deadline in 2020, FDA initiated a process by which they virtually denied virtually all applications for flavored products if those applications did not have that comparative efficacy study that I mentioned. And they did this right at a point in the review process prior to initiating the actual scientific review. They conducted what's called a fatal flaw review to look through that application to assess whether it actually contained that study. And you can see here, on my screen, that happened right between filing and the review stage, where they would do that comparative efficacy or fatal flaw test. And what the result of that was, nearly all applications for non-flavored ends submitted either after one of the deadlines or the last several years were denied if they did not contain. They're automatically denied if they did not contain that specific type of fatal flaw study. And then what happened in reality is even the applications that managed to survive that initial purge, and for new applications submitted over the last several years, those applications have remained in a sort of purgatory even after being accepted for years without any communication from FDA, without any feedback from the agency. We've seen applications sit for 4, 5, 6 years and not moving through the scientific process. And as we'll discuss later, some companies have now started actually challenging FDA because of these long delays. And so again, the process in reality has been very little transparency, little to no communication until you get a letter from FDA that says you've been refused or denied, or possibly even an enforcement action. Also, what we've also seen, unfortunately, is that while the PMTA process is supposed to be scientific, it's supposed to be science-based, you're making a decision on whether something is APPH, increasingly it's become clear that the process is also very political, right? We saw that for years with the Juul product and the discomfort with FDA and getting those authorized, which eventually they did for menthol and tobacco. And most recently with a company called Glass, who submitted applications for a vapor device that contained flavors as well as tobacco flavors, and also that device also has age gating technology, which we'll discuss. And if you saw the news recently in the Wall Street Journal, that application was actually approved or authorized by the FDA scientific staff, the Office of Science, but several of those, basically the flavored versions of that product was the approval, the authorization was blocked by the FDA commissioner, and it's still, still in limbo. It hasn't been denied yet, but it's still being reviewed. So that kind of thing where it's become very political, that obviously is not the way it's supposed to work. Clearly disincentivizes companies from participating in the process. It disadvantages companies who are attempting to comply and fuels the illicit market. But it's possible that changes could be coming. CTP Director Brett Koplow recently spoke at a conference and indicated that FDA is making significant progress in a number of areas. They've apparently reduced the PMTA backlog by 70% in 2025, and their priority remains to completely eliminate the backlog. What that means is a company could submit an application, and in an ideal world, FDA would start their review immediately. Of course, I say all this with a grain of salt because when FDA says they're reducing the backlog, in reality, what that means is they've just refused and denied more products, right? And possibly in an arbitrary and capricious manner, which is being challenged in court. So, again, reducing backlog sounds like a good thing, but for many small companies out there, that just means your applications are likely getting refused or denied. One thing that we've seen in terms of progress being made that we'll talk about is this pilot pouch program, where for nicotine pouches, FDA is started a program to review certain applications in a different way with more transparency, more communication to get it done quicker. And that has resulted in some success, limited success. And FDA has indicated they will soon publish a lessons learned guidance document from that pouch program that we hope will extend to other categories such as e-cigarettes. Okay, so everyone's main concern is flavors. Will flavors, particularly vapor product flavors, have a future? Well, let me take a step back here. The reason flavors are a concern, hypothetically, is because of the risk to youth, as I mentioned earlier. Well, there's been a lot of good news on that front, right? You've been following the data. The youth usage of vapor products in general has fallen dramatically over the last several years, right? So back in 2019, we had the peak of youth vaping concern where, significant portion of high schoolers and middle schoolers were vaping, somewhat, at least once every 30 days. That number has declined dramatically to the lowest level since I think 2010, when the industry was just starting, down to 7.1% of high school students who have reported using a vapor product at least once in the last 30 days. That is a significantly lower than where we've been. Here's another graph to show you just exactly how far things have fallen when it comes to vaping products. You see the peak here, and then all the way down to 7.1% of high school students compared to years past. So again, tremendous progress has been made here, in large part due to the age to purchase tobacco being raised to 21 nationally back at the end of 2020. That's where we really saw things continue to decline. So again, great progress. And what does that mean for FDA in terms of their policies when it comes to flavors? Because again, flavored vapes in particular, because we know that what initially drove FDA towards a comparative efficacy requirement was the concern over youth vaping. Earlier this year, back in March last month, FDA published a new draft guidance on flavored ends. And what that guidance does, a few slides here, is really it doubles down on the comparative efficacy requirement for flavored products. And what FDA is doing now is they're now expressly recognizing a flavor-specific risk framework, whereby certain flavors potentially pose more risk than other flavors in terms of youth use. and therefore may require additional data, right? So now we're going to get into what that means. Well, FDA has now acknowledged in this draft guidance, which by the way is just a draft, it's not final and it's subject to changing, and we hope it does change for a lot of reasons. But FDA is now acknowledging that again, different flavors pose different risk. The lowest risk flavor is obviously tobacco, right? As I mentioned, the flavors that are of lower and intermediate risk are obviously menthol, which they said the data now shows menthol is not likely to be used by youth, as well as kind of these mature flavor profiles like mint, spice, coffee, tea type profiles. What remains a higher risk category is things like fruit, dessert, candy, sweet flavors, which are obviously probably the more popular flavor profiles for vape. Those are still in the highest risk category and therefore could require more data to demonstrate additional benefit. The good news from the guidance is this was the first guidance where FDA does seem to incorporate language um, that recognizes that youth ends use has declined sharply, and that ends products, vape products, have a potential benefit for adult smokers. There's a harm reduction approach here, so that's good. But again, this doubling down on the need for comparative efficacy data, which again, the type of data you need is going to be something robust, a randomized control study, a longitudinal cohort study that's going to require significant funds to complete. That's going to be still the core of what is needed to get a flavor authorized. FDA also recommends other types of data, which is really not clear at this point, what those studies will look like, but things like sensory perception and consumer response studies may help assess youth appeal without product use, without actually giving the product to a young person. So, there are all these sorts of different kind of things being thrown out there in this guidance document, but FDA does encourage companies to actually try to meet with them in advance of initiating any study designs. The guidance also mentions device access restrictions. So that's something that the glass product I mentioned incorporates. That's still waiting for FDA approval of their flavors. But device access restrictions are basically built-in technology into the hardware of the device, either age gates at the point of sale or age gates using a Bluetooth connection to your phone, or possibly biometrics or geofencing type technology. In the past, the FDA has said, only these types of built-in age device access restrictions would be enough to mitigate the substantial risk to youth posed by flavored vape products. Because in FDA's view, other types of marketing-based restrictions are not going to be sufficient to reduce the risk to youth. And so you have to build in this technology into the device in order to really have a chance of mitigating the risk to youth. So FDA does mention in this guidance that type of evidence will be considered. It's a positive sign that for the companies that are investing in this technology, that this is going to be helpful to getting authorization. However, it will not be the only thing that will get authorization. You will also need to overcome the burden of flavored products and do those specific types of studies to demonstrate additional benefit for adults. That is not going to go away. And one thing that I've written about and spoken about in the past is to what are we really doing here? Does it really even make sense for FDA to require companies to compare their non-tobacco flavors to their tobacco flavors? Is that something that even makes sense? Because tobacco flavor is not an inherent quality of a nicotine product. Vapor products are not inherently tobacco flavored because they don't contain tobacco. So why are we comparing these to tobacco flavored e-liquids? right? Those are all just chemically made products. What FDA should be looking at more specifically is the comparison of the vape product, whether it's flavored or not, to a combustible cigarette, and how is it reducing the harmful effects on consumers and benefiting the population at that level. Again, something the FDA does do, but again, I think the focus on the comparative efficacy on tobacco flavors is probably a bit misplaced. So the bottom line for applicants, the draft guidance gives a clear, um, it gives us more understanding of where FDA is going with flavors. It doesn't create a shortcut for authorization. It still makes clear that flavors, especially the higher youth appeal flavors, are going to require even stronger adult benefit evidence. Um, and so again, it's still kind of doubling down on that position that they've been taking since 2021 on flavors. However, again, as I mentioned, it's important. This flavor guidance is not final, and companies, including retailers, should submit comments before the deadline on May 11th to voice your concerns about FDA's regulation and their policy around flavors. All right, I want to give a quick update on the ends that have been authorized by FDA. So this table here, as you can see, there's a limited number of companies that have actually succeeded in getting getting a product through the PMTA process. Nearly all of them big tobacco companies. Glass and Juul are independent. Glass is obviously a small company relative to the rest of the pack here. Virtually all are tobacco flavors, a couple of menthol flavors, and so a very limited universe of things that have actually been authorized. Um, so again, just demonstrates how difficult this process is. For those products that have been able to successfully navigate, here are some key kind of features, right? Those products have all been able to have lower abuse liability compared to usual brand of cigarettes, reduced tox profile, HPHCs compared to cigarette smoke. They are effective nicotine delivery products that will benefit switching adult smokers. They demonstrate, at least for the menthol products, um, sufficient comparative efficacy, adult benefit to a tobacco flavor product. So, for example, Enjoy included data demonstrating that up to somewhere between 25% to 50% of consumers in their study who were using menthol were likely to switch relative to the tobacco flavor. So huge adult appeal combined with lower risk, youth risk mitigation and marketing controls, and strong manufacturing systems. So that is what was needed to get those products approved, right? But again, we still haven't seen FDA go all the way with a non-menthol flavor. The closest that we've come so far has been this glass product. And so what happened there is a bit of drama. It's been in the news recently, but in the Wall Street Journal, as I mentioned, the background here is that back in 2021, Glass submitted a PMTA for their G2 device in several flavors. Mango, sapphire, which are the flavored products, menthol, and classic menthol, and then several tobacco pods. Um, After 4 years, right, nearly 4 years, FDA approved or recommended marketing granted orders for all 8 of those SKUs. But then FDA pulled back, and it went up to the commissioner, and in the memo, they directed the CTP, the Center for Tobacco, to refrain from issuing marketing granted orders for those flavored products, Gold, Sapphire, Fresh Menthol, and Classic Menthol. Right? The reasoning was, and remember, this was a device that has built-in age gating technology. I think it's a Bluetooth type technology that would lock the device and prevent it from being used by anyone who, without it getting unlocked by the actual user. FDA's rationale in at least currently holding back on those PMTA authorizations is that they have limited experience evaluating device access restrictions in these applications. So they're looking at it, more carefully. They're age gating it, even though again they've been kind of pushing companies in this direction now for several years. FDA was preparing a flavored ends guidance, which I just went through. So I think they wanted to maybe see, um, get that out there in the public domain before issuing these authorizations. So maybe that means we'll get an authorization soon now that guidance has come out. And FDA, I said that they remain concerned that youth and sellers could still circumvent the access restrictions through a variety of ways, right? And so, you know, still a lot of hurdles to overcome. Glass responded to that and said, well, hold on. You're only, that's not the only reason. Just the fact that this product is age gated is not the only reason why this should be approved. They also included significant other data, to prove the product on its own meets APPH, right? Including switching data, actual use data, perception data, population health modeling, the age gating validation information, anti-counterfeit controls, et cetera. So again, they submitted a complete application. They survived the fatal flaw denial, got into scientific review, responded to FDA's deficiencies, and so they did everything. And again, it seems for political reasons, it's being held up. We will see what happens. Hopefully they get authorized and they open the door. I think that will be huge for the industry if FDA, if it can, can get over this hump and approve a flavor. Right. Just a quick mention, several other devices that have submitted applications, or companies have submitted applications that include age gating software or technology, include Juul. They've submitted their Juul 2.0 product, which has been around actually for several years in the UK. That is now FDA pending since July 2023. So, basically almost 3 years now. That also contains Bluetooth enabled age gating technology. It comes in tobacco and menthol. So we will see if that, now that this guidance has come out, is enough to get over the hump here. Switching gears to oral nicotine pouches, obviously growing in huge popularity. So I want to cover that today as well. The good news with pouches, unlike flavored vapes, which are still struggling to get that authorization, FDA has already authorized several flavored pouch products. The first was the Zyn pouch in January of last year. They approved the Zyn in multiple flavors, 10 flavors, in both 3 and 6 milligrams. Okay, and that application was actually submitted back in 2020. So he sat around for a long time, and had a very, very comprehensive application that include switching data. Zyn was able to demonstrate that nearly 25% of users, adult users, switched completely to Zyn away from their cigarettes within a 10-week study. A huge adult benefit. This product is also now separately going through a modified risk approval process to get certain claims approved that indicate that this product is less harmful than smoking. So we'll see if that happens. Just going through some of the things here. So after the Zyn authorization in January of last year, we hadn't heard anything much from FDA on pouches. Then in September of 2025, FDA launched this pilot program that was all over the media because the big tobacco companies had lobbied the Trump administration and the HHS and said, our applications have been pending in many cases for several years. FDA needs to start moving these through. And so FDA launched this pilot program to review the pending applications for some of those products from those companies that have been sitting around for a while. And the goal of this pilot program was to treat this a little bit differently than the way it's been working, right? The goal was to streamline the review process while still maintaining the scientific rigor. There was a lot of confusion early when this announcement came out that does this mean FDA is reducing the scientific burden, moving away from APPH? The answer is no. FDA has made clear recently they are maintaining the scientific requirements, but this is more about process. And basically, let's conduct an experiment around process and things like communication and collaboration to make the review go more quickly, the scientific review go more quickly. And they did this with pouches specifically because pouches are a lower risk product. They're more homogeneous than ends. They're very simple products. And so it, seemed to make sense to kind of start this pilot with pouches. And so what changed? So again, talking to companies who are into this process, who have been speaking about this more recently, but what changed the most was that FDA basically um, did something that sounds very novel to them, but which was communicate with the companies and send emails to the companies and have calls and meetings with them in real time to discuss issues that they were seeing in the applications, rather than the old process, which was you got one deficiency letter, you had 90 days to respond to that letter, and that was it. They weren't going to extend the time, or rarely. They weren't going to issue, in most cases, a second letter. Um, you know, this was a much more iterative collaboration with the companies to try to make sure they could get all the data needed for authorization. FDA's core areas of focus was characterization of the product, consistent manufacturing, demonstration of adult benefit, and access reduction to kids. Ultimately, again, FDA's review demonstrated that this could be effective. FDA's they focused on those core issues of adult switching, youth risk mitigation, and population benefit. And the key takeaway is that, hey, companies, you need to do the studies. You can't just rely on low toxicant exposures. They want to see actual complete population health data. Okay, and so one product has succeeded has come out of this program with an authorization. That is the On Plus, right? That product from Altria took about 1 year from submission to get authorized. It comes in mint, tobacco, wintergreen. So again, not a huge variety of flavors, but still flavors nonetheless. And those were authorized. They included both longitudinal data, which again, the switching data showing that smokeless tobacco users and cigarette smokers were able to switch and reduce their tobacco usage with their product. So now the question becomes, okay, we have a couple of authorized brands. Well, what about the dozens and thousands potentially of non-authorized products on the market? Is FDA going to start enforcing those products? We're starting to see some of this moral panic starting again with pouches, even though the NYTS and youth data are demonstrating continued low usage of youth use. So kids are not using pouches at a high rate, even though we have so many flavored pouches on the market. But the question remains, will FDA really start pushing to enforce? Right now, their enforcement priority is, of course, flavored disposables from China. And so they haven't prioritized enforcement of oral nicotine products. Again, there are reasons for why perhaps they may not do that, because we don't have a youth issue and because these are much lower on the continuum of risk. But FDA has said, hey, in the meantime, if you're on the market, get your PMTAs in, make them complete, include child-resistant packaging, and our hope is that companies that do that can avoid FDA enforcement. That said, we have over the years, we have seen some FDA enforcement. We have seen some warning letters issued to nicotine pouch products for being on the market without authorization. So again, it is very possible that FDA will enforce against companies that are marketing these products without MGOs. Quick update on the PMTA challenges that are still pending. So many companies who, on the vape side, who received marketing denial orders for their flavored products sued FDA for those decisions for a variety of reasons, namely that FDA failed to provide proper notice of that comparative efficacy study, as well as we'll see, FDA did not go through the rulemaking process to make that, which essentially was a standard, a requirement, that they did not go through that process in the proper way. I won't go through them all, but there's a number of cases. Again, at least, probably 50 to 75 cases that have been filed over the last several years. The key cases I wanted to mention briefly was the wages case, which went up to the Supreme Court last year, and was a key case that has now been remanded, and then a case that we recently argued in the Fifth Circuit called Niquid. So the main arguments in these cases, as I mentioned again, is that FDA acted in an arbitrary and capricious manner in violation of something called the Administrative Procedure Act by um, by denying those flavored applications without reviewing them and just looking for the comparative efficacy study. Um, so that's kind of the main argument. The issue that went up before the Supreme Court was the issue of fair notice, of whether companies should have known that that study was going to be required for flavored products. And unfortunately, the Supreme Court ruled in the FDA's favor. It said, well, if you look at the history of FDA's guidance documents, companies should have been aware that FDA was going to focus on flavors and that FDA was going to require them to compare those flavors to tobacco flavors. And so there was no change in position or surprise switch to require that study. Okay, so that's where the Supreme Court landed on that issue. However, that case is not over. It has been remanded back to the Fifth Circuit. There are a number of other cases. We just argued last week in the Fifth Circuit for a group of 7 companies, e-liquid companies, who had their PMTAs denied. We argued that FDA did not do that properly, that their denial, the basis for those denials, requiring the comparative efficacy study, was effectively a tobacco product standard that should have gone through rulemaking, and FDA failed to do that. So again, we'll see what happens in those cases, and hopefully we'll come out with a victory there. Other key cases to watch, away from the kind of MDO challenge, there's the Enjoy versus FDA, which is a challenge of FDA's failure to review an administrative appeal, a 1075 administrative appeal that they had filed internally at FDA for an MDO, which apparently the FDA has been sitting on for well beyond 180 days, or I think it's over 3 years that they've been sitting on that appeal. Similarly, there's the Swatch e-liquid or USA Vape Lab versus FDA. That is a challenge to FDA's failure to simply not review an application. This is an application for bottled e-liquid that went in back in 2020, and FDA has not moved that through the review process. And even though they haven't done that, and the ball's in FDA's court, those products were recently part of a seizure at a distributor, and FDA saying, hey, that distributor is marketing these products illegally or distributing them illegally. Well, hold on, how can you do that when you're the one sitting on my application for 5 years? So that challenge is now pending. We also have a couple of challenges for the pouch companies that submitted applications and received refused to file letters. As I mentioned early on, the filing process is the second process, the second phase of that process. And so those applications refusals are being challenged for various reasons, namely, FDA missed the information, or FDA somehow should have accepted and filed those applications because they did include the data needed to go into scientific review. In terms of an enforcement update, FDA's enforcement priority remains unauthorized ends, in particular flavored disposables from China. That is going to be FDA's #1 concern for a variety of reasons. But beyond that, anything that's on the market without a marketing granted order is subject to enforcement. FDA makes clear on their website that having a pending application does not in and of itself create a safe harbor for selling the product for retailers, right? So retailers, distributors, manufacturers of unauthorized products all remain subject to FDA enforcement, right? However, FDA does look at enforcement on a case-by-case basis, considering youth use and other risk factors, right? And so, um, if a product does not have a significant youth risk concern, if it's not being used by kids, again, if it's tobacco flavored or if it has other features, or it may not be as likely to be enforced against versus something that is kid friendly. But nevertheless, anything on the market without authorization is subject to enforcement. In terms of FDA's enforcement tools, they have a variety of tools, including warning letters, import alerts, civil money penalties, seizures, and injunctions. Linked here is a really helpful flow chart that will kind of walk you through the steps that FDA goes through in terms of enforcement. But basically, FDA, they do their investigation first, right? Whether it's an online for a website or in-person inspections to your warehouse or retailer. I'm sure many folks here have been inspected by FDA. Um, they will obviously look at things coming in from the border, at the border through customs, and they will also review your filings with the agency to see, okay, well, what's out there and what should we prioritize our enforcement against. I think in 2024, there was major announcement that FDA was joining a federal multi-agency task force intended to curb the illegal distribution of vape products, right? So this is the FDA, the DOJ, the ATF, and other organizations, other departments coming together to coordinate the enforcement of products, which has resulted in a number of very high-profile seizure of products, right? We see these in the news every few months, major seizure actions where millions of dollars worth of illegal vapes are caught and destroyed. There was a major seizure in July of last year that's not mentioned on the slide, but many companies here, I'm sure, had products that were caught up in that seizure in the Chicago area. So every few months we see this big showing, and then things kind of seem to die down, right? So it kind of ebbs and flows. And so, I think FDA is trying to get to a point where they have this consistent enforcement against unauthorized products. Warning letters is the first step, right? So technically, a warning letter is not an enforcement action. It is FDA basically sending you like a cease and desist letter telling you, hey, they've identified that you've sold an illegal or unauthorized product, and you have to now, respond to FDA within 15 business days. How do you do so? If you ever get hit with a warning letter or enforcement action from FDA, reach out to a lawyer and make sure you do respond, because if you don't respond, that will result in additional violations. Again, FDA's primary focus are things that are youth appealing. So again, vapes that are designed to look like kids' toys, foods, video games that have built-in video games or interactive features, smart vapes as they call them. Those are obviously going to be a higher priority for enforcement than a more simple device. FDA has come to trade shows. And so, be aware at the trade show, whether, your FDA is there and, if you're approached by an FDA official, make sure that you direct them to a supervisor or a lawyer who can talk about the status of your products, who's knowledgeable about the legal status of your products, because FDA has in the past been known to hand out warning letters, after finding illegal products at trade shows. So just be aware of that and reach out to an attorney if you have any questions. Importation blockage is another key tool of FDA is actually blocking importation of products through import alerts, something that we've seen ebb and flow over the last several years, where we had a period of time last year where nothing was getting through, right? FDA, the customs and the administration basically shut down the border, issuing tariffs as well. And so we saw a real, a decline in imported goods, imported vapes. That has seemed to subside as the market appears to demonstrate, more products are getting through again. So again, it remains to be seen how FDA, if FDA continues to implement this type of enforcement in a more consistent manner. Civil money penalties. So if you get a warning letter and you don't respond to it, or FDA is not satisfied with your response, you could get a civil money penalty, right? That can be up to $21,000, almost $22,000 per violation. They're issuing those to retailers as well as distributors. And so be aware of that. You could get a significant fine from FDA, and it's important that you either challenge that or you pay the penalty and settle with FDA. Because if you don't, then that could lead to further enforcement, such as injunctions, where they can actually physically go to court and stop your business, right? Civil money penalty actually doesn't result in FDA shutting you down, but an injunction can do so. And that can be very expensive to have to defend yourself in federal court. And typically, what most companies do is try to enter into a consent decree or a settlement for a permanent injunction to basically avoid having to comply with that and to challenge FDA and go to court. So that is kind of the worst case scenario. It can really shut down your entire business and prevent you from doing business in this category at all. All right, so next I'm going to talk about nicotine analogs, right? It's a growing area of the industry, and so I wanted to make sure that I touched on that because the question I get a lot is, well, how is FDA going to regulate these products? They're not nicotine, they're not tobacco, and so how could they be regulated? Well, um, if you understand how the FDA regulates products, they have different buckets, right? Some things are medical products like drugs and devices, or tobacco, or food, or cosmetics. But FDA has these buckets of things that they put things in. When it comes to nicotine analogs like 6-methyl nicotine, first and foremost, it is not actually nicotine. So a product that contains an analog that otherwise doesn't contain nicotine or tobacco-derived substances would not meet the definition of a tobacco product that I mentioned earlier, right? And it may not meet the definition of what's called a component and part of a product um, if that product is not intended to be used with nicotine or tobacco, like an open system, right? And so if a product contains zero nicotine and does not contain any tobacco-derived substances and is not intended to be used with tobacco, then FDA itself in the past has put out there that that would not be subject to regulation as a tobacco product, right? So that's kind of where we sit now with these products. But if it's not a tobacco product, well, then what could happen? Well, FDA could hypothetically come after these products as drugs, right? Because the definition of a drug is very broad. It's anything intended for the use in the diagnosis, treatment, prevention, cure of a disease, or anything it's intended to have the effective structure and function of the body of man. And so those products, to the extent that they are functioning with the body, FDA has the authority now without any congressional authorization needed to come after those products. Has FDA done that? No. And so far, we haven't seen any indication that they're looking at that. We thought many years ago that FDA was going to go down that path with synthetic nicotine, because synthetic nicotine, arguably fell within the definition of a drug, but they chose not to. They went through Congress and amended the definition. So we could see that kind of thing happen here. We could see at some point if these products become popular enough or present a problem big enough, you could see Congress acting again like they did in 2022 and redefining tobacco to include not just nicotine, but nicotine analogs like 6-methyl nicotine, and therefore could require these products to go through PMTAs and everything else. In terms of enforcement for non-nicotine vapes, we have seen enforcement. Again, so far that enforcement has been limited to products making inappropriate claims, right? Therapeutic claims, treating disease, addictions, etc. So, if you are going to market those types of products, make sure you don't use any kind of potential therapeutic or drug claims, because that will get you FDA's attention. Now, briefly, I'm going to talk about state regulation. I know I'm going kind of long here, but I wanted to touch on this. Um, the way the law works, the federal law, the Tobacco Control Act, is by and large controlling. And FDA can't, the states can't touch the things that are covered by the Tobacco Control Act, the federal law, such as manufacturing standards, etc. Um, but there are certain things that are not preempted by the federal law. And those are things related to the sale of the product by and large. And so what we're seeing now, more and more of is more and more states passing things that are falling under the scope of a sales restriction that is not preempted by the federal law, and resulting in, for example, state flavor bans, right? So more and more states have flavor bans, including a handful here: Maryland, New Jersey, New York, Rhode Island, Utah. Um, California has had one for several years, Massachusetts. All of these states are in some way, shape, or form banning flavored products or certain types of flavored products, which they're allowed to do, right? There have been challenges to those laws, but um, won't get into it here, but those have not been successful. In addition, you have to consider the local laws, right? New York City, DC, Chicago, the big cities, in many cases, have their own flavor restrictions and sales restrictions. And so you have to be aware of what those are if you are selling into a city or state, one of these types of products. We've also seen, separate from the flavor bans, another category of state law called directories, right? We're going to have more discussion on this later on, but the state governments have passed these directory laws that essentially identify what products can be sold in those states if they could qualify for listing on the directory. Those listing requirements typically revolve around the PMTA status of the product, the FDA status of the product. So whether the product has an application that is still pending with FDA that was submitted back in 2020, that is not subject to a flavor ban or a marketing denial order. So it kind of limits the products that can be sold that meet those state listings requirements. But we're seeing more of those states. Many of those state directory laws are being challenged right now for stepping on FDA's toes or crossing the line. And so there have been a couple of victories there, but it seems like that's where the states are going. That's pretty much where big tobacco is pushing the state legislators to create these types of listing requirements because, again, based on what has been approved by FDA, it's those companies who have products that will, by and large, survive the listing process and be allowed for sale in those states. And so it looks like, again, here, more and more states have passed these bills or have laws that are pending that would create similar directories. So again, if you're a retailer or a distributor or a manufacturer located in these states, it's important that you pay attention to what's happening, and so that you are fully aware of how to stay in compliance as much as possible, in this category. So I know that was a lot of information over the last almost an hour here. It's technical, it's complicated. And there's more out there I didn't cover, but hopefully some of you came to our e-vapor symposium, and we'll have more of these in the future. Happy to do more webinars for champs. Here's my contact information. Please feel free to reach out, and we can hopefully have some discussion, and happy to help you comply with the law as much as possible. So enjoy the show, and I will look forward to hearing from you. Thank you.